You everyone for joining our webinar on the ABCs of sanctions. This is Kay Gannan of the Charity and Security Network, and we're pleased to have so many people joining us today to get background from an expert on this very important and very timely topic. We're going to focus today on U.S. sanctions, although as you're probably aware, there are also sanctions imposed by the United Nations Security Council, the European Union, and others. But for today, we'll focus on U.S. sanctions, which is a topic that is large enough to take us for a full 90 minutes. We are very happy to have a true legal expert to guide us through this terrain. Erich Ferrari of Ferrari Legal Associates will be our speaker. And we really appreciate his taking the time to do this. He's been an advisor to us on sanctions or helped us to navigate this territory ourselves and looking at the impact of draft legislation and other issues for some time, and we really appreciate that help. I also want to give you an idea of the agenda. Because we have so many participants, we're not going to be able to take your Q&A by voice. So as we go through each segment of the agenda, we'll stop where I'll have a question for Erich myself, and then we'll take some time for you to ask questions. And to do that, please use the question and answer box at the bottom of your screen. And we'll take the questions from there. The system records the questions, so if we don't have time to get to yours, we'll go through these and answer them by email later on after the event. Also want to let you know that this event is being recorded and will be posted on our website along with the PowerPoint. So with that, without any further ado, I'm going to turn the agenda over to Erich.
Thanks, Kay. Appreciate you having me on, and thanks to everyone who is joining today. Today we're going to be covering the basics of U.S. economic sanctions, the different kinds of sanctions, how sanctions are enforced, what latitude is provided to humanitarian efforts under those sanctions programs, and some practical considerations for compliance. Can we go to the next slide, please? It didn't change on my end.
Yeah.
Oh, there we go. Fantastic. So these are the topic areas we're going to be discussing today. As I mentioned, general background, the categories and types of sanctions, sanctions consequences, and when I say sanctions consequences, what I'm referring to is civil and criminal penalties under certain sanctions programs and for certain sanctions violations, as well as the consequences for engaging in sanctionable conduct and what the difference is between a prohibited activity and a sanctionable activity. We're also going to spend some time talking about humanitarian exemptions and guidance that OFAC has provided with respect to humanitarian exemptions. I think we moved a little bit too quickly. Can we go back one? And then finally, we'll be talking about practical compliance challenges. And I think one of the biggest areas and one of the most important areas here is figuring out, okay, you have these laws, you have this agency that administers those laws, but how does this play out in the private sector? How can you actually implement your compliance measures to make sure you're following the law? How do you deal with counterparties who may have varying interpretations of the law? How do you deal with banks who have to process payments related to humanitarian efforts that are impacted by these sanctions laws, so on and so forth. So I think we can move on now to the next slide. So what are sanctions? I put a kind of definition that I like to use myself in here. I don't think there's one single definition of sanctions anywhere, that's at least not in any kind of legal text. The term sanctions is thrown around a lot, and it's used in a variety of different contexts. And indeed, sanctions can mean a variety of different things and come in many different forms. So it's not strange that you wouldn't have one universal definition of what a sanction is. But what I've defined it here as are laws that seek to protect, and I'm talking US sanctions, of course, for purposes of this discussion, but laws that seek to protect US national security and promote US foreign policy by coercive means that are intended to shield the US financial system from malign actors and activity and compel those targeted by sanctions to change their behavior. Obviously, I'm a lawyer, so that's maybe not the most wieldy definition, but that's kind of hits all the main points that I think about when I'm talking about US sanctions. Let's just take a moment before we get too far into the presentation to discuss what it is that these sanctions are that we're discussing. What do they do? How are they used? And how are they becoming more and more relied upon to address contemporary geopolitical events? First, as I noted before, when I'm talking about sanctions, I'm referring to laws, rules, governmental actions that target a particular country, organization, entity, or individual in response to that target's conduct. And the intended purpose here is to impose a consequence upon them in the hope that the harm arising from that consequence is sufficient to change the target's conduct. Typically, this takes the form of an asset freeze or prohibitions on or consequences for providing support or services to the target. With respect to how they've been used, there's a long history of using sanctions. How long? Well, if you consider this, during the Peloponnesian War, the Athenian ruler Pericles forbade the Greek city-states that refused to join the Delian League from importing from another Greek city-state, Megara. And I might be butchering those names, so apologize for any mispronunciations there. But that embargo, import embargo, occurred all the way back in 432 BC. So we Americans are certainly not the first to use economic sanctions. Sanctions have been around for a very long time. But despite being so late to the game, both in terms of America appearing on the world stage as well as our use of economic sanctions, we've quickly caught up. Since the War of 1812, the US has been using economic sanctions in one way or another. And for the overwhelming majority of that period of time, sanctions were used to target countries that acted contrary to our national security and foreign policy interests. It wasn't until very much later, and when I'm saying later, I'm talking about the mid-1990s, that organizations, entities, and individuals who engage in conduct contrary to US national security and foreign policy interests became targets of these various sanctions regimes administered by the US. If you look at prior to the 1990s, or really prior to the Clinton administration, the US's use of sanctions was sporadic and usually tracked along with very public and contemporary political events. So Cuban Missile Crisis, the war in Vietnam, the Iran hostage crisis, conflict in the former Republic of Yugoslavia, for example. Then in the mid-1990s, the US began using sanctions against organizations, individuals, and entities. And really it started to do so with terrorist organizations as well as with drug traffickers in Colombia. Later, the US expanded the scope of the conduct they sought to address through US sanctions by targeting human rights abusers, people involved in corruption, the annexation of certain geographic areas. And basically what it's become now is anything the US doesn't like that's happening in the world, they use sanctions. And so, and I'll talk about this in a moment, but just over the past week or so, there's a bill that's been passed and there's been talk about use of sanctions against China for undermining the independence of Hong Kong. And so that's a big topic now in the sanctions world. So any kind of thing that's going on in the world these days, it does seem that sanctions are the US's first choice in responding to those events, assuming, of course, that those events are contrary to US interests. Literally, you can't turn on the news or read a newspaper, if anyone is still reading newspapers and not reading everything online, without hearing about new sanctions. So as I mentioned, US Congress had just passed this bill, and that bill is intended to target Chinese officials involved in compromising Hong Kong's autonomy. But there's not a week that goes by where you don't hear about new sanctions designations or actions taken against Iran. Just yesterday, there was a designation of 2 individuals in Iran by the State Department under the Counter-Proliferation of Weapons of Mass Destruction program. Actions being taken frequently against Venezuela, constantly against terrorist financiers, particularly where there's an overlap between Iran and that financing. And you're also hearing not just about these designations and these actions, but also criminal prosecutions under sanctions programs for smuggling, illegal money exchanging, and even some of the world's biggest banks have been caught up in these hundreds of millions of dollars and sometimes billions of dollars penalties and fines for violating these sanctions programs. So the basic point here is, in short, sanctions have been around forever, but they've never been as pervasive as they are today. And, you know, maybe this is just me kind of philosophizing a little bit, but it seems to be indicative of our modern political disposition towards conflict as opposed to dialogue, that we're seeing so many sanctions, and that sanctions that were once thought of as being such a drastic measure are now business as usual in modern diplomacy. So let's talk a little bit now about who administers sanctions, to give you an idea of how they actually come together, who's involved in the process, what are the different roles in that process, and what are the considerations that go into that process. And I would note that this is actually really important, as sometimes understanding and knowing the inner workings and considerations can help interpret what the sanctions actually mean in terms of how the regulations are expressed as well as how the guidance is expressed. So there's no way you can talk about US sanctions without talking about the United States Department of the Treasury's Office of Foreign Assets Control. Likely many of you on this webinar have heard of them. That's OFAC. Within OFAC, and just for those of you who don't know, OFAC is the primary agency involved in the promulgation of sanctions laws, administering and enforcing those laws. So they're kind of the primary administrator of US sanctions programs. And within OFAC, there are different components or divisions to be aware of. You should be aware of the Sanctions Compliance and Enforcement Division. They do a lot of the outreach with respect to guidance, and a lot of the public-facing guidance that you see comes from Sanctions Compliance and Enforcement. They also handle enforcement cases involving financial institutions. You have the Licensing Division, which is responsible for tailoring US sanctions programs by issuing general authorizations, statements of licensing policy, and specific licenses, all of which we'll talk about in a little bit, to mitigate any kind of ancillary or unintended harm arising from the sanctions programs. You have the OFAC Enforcement Division, which is the enforcement arm that deals with non-financial institutions and enforcing against violations of OFAC's various sanctions programs. And you have the Office of Global Targeting. And the Office of Global Targeting is responsible for identifying sanctions targets and imposing sanctions against them. It also conducts investigations based on information received from a variety of sources that may or may not be used to designate parties. And they also administer the delisting process to determine whether there has been a mistake or a change in circumstances warranting the removal of sanctions against a particular party. So that might sound strange to you, but targeting is both the component responsible for putting people on the list. It's also the component responsible for determining whether they should come off of the list. So a lot of times they are thought of as judge, jury, and executioner in respect to these sanctions designations. So they're a very, very important component of OFAC, although maybe they're not as public-facing and getting as much attention as some of the other divisions. And I think one other note on targeting that's important to keep in mind is they don't have all of the power to designate, and neither does Treasury. There is also power that's held by the State Department with respect to certain types of sanctions designations. So going back to something I said earlier, the individuals who were designated yesterday were under the Counterproliferation of Weapons of Mass Destruction program were actually designated by the State Department. But what OFAC often does is when state or another authority sanctions a particular party, Treasury and targeting look to build out the networks connected to those sanctioned persons to find additional targets who are either owned or controlled by, acting for, on behalf of, or providing support and services to those targets. This doesn't happen in a vacuum, of course. There's a lot of interagency coordination. And so kind of these US sanctions actions come to pass, whether through the issuance of an executive order, specific designation, or issuance of an authorization through an interagency process that typically involves, and it's not a uniform process for every action, but typically involves the National Security Council, aka the White House, the State Department, and different components within Treasury. So not just OFAC, but also other components of the Office of Terrorism and Financial Intelligence and the Office of Intelligence and Analysis. And the State Department is always involved in these actions as well because, maybe I'm biased here, but the lawyers always have to be involved and to make sure it's legal, at least from the Department of Justice's perspective. The interagency process also coordinates the actual sanctions program. So in that process, the NSC and the State Department typically have some level of involvement, but you might also see other agencies involved in program coordination depending on the type of threat or emergency that's being addressed. For example, in the non-proliferation of weapons of mass destruction program and the counterterrorism sanctions programs, you'll have other agencies of the intelligence community involved. So maybe, for example, the CIA. Under the counter-narcotics or transnational criminal organizations authorities, on the other hand, you have law enforcement agencies involved, such as the DEA. DEA is obviously very involved in the counter-narcotics sanctions programs. And again, depending on the type of sanctions program that we're talking about, you might have other types of regulators involved in coordinating with respect to some of those programs. So it's not unusual to see the Federal Reserve involved in coordination, the Office of Comptroller of Currency, the Security Exchange Commission, FINRA, the FDIC, and others, for example. Everything in this process kind of starts, of course, from the top down and then filters down through the cabinet level to OFAC, and also rises from bottom up from these different agencies of the intelligence community and law enforcement up to OFAC. So OFAC is effectively a central node in this process, and that's how they come to be the primary administrator of U.S. sanctions programs. But the interagency is not the only coordination that goes on. So sometimes you'll have coordination with the United Nations or foreign governments where they will either coordinate or be consulted with respect to particular sanctions actions. And this type of multilateral coordination is what can really make a sanctions program particularly effective. So for all the bluster you hear about how strong U.S. sanctions authorities are and how tough the U.S. is being by imposing sanctions, sanctions are most effective when numerous countries impose or enforce them on particular targets. And so one of the things that I saw, particularly around the time that the Joint Plan of Action and later became the Joint Comprehensive Plan of Action, the Iran nuclear deal, was that the Iranians were less concerned about U.S. sanctions relief and more concerned about sanctions relief from the EU and other places, because that's what was really impacting them more than anything. They had already been under U.S. sanctions since the mid-90s, but it's in the early 2010s and the mid-2010s when EU sanctions became more aggressive towards Iran that they were really, that pressure led them to come to the negotiating table. And this is, that's not just speculation. You see it now as well with Iran up until recently continuing to abide by the JCPOA so long as the EU was staying in the JCPOA, regardless of the current administration's decision to withdraw from that agreement. Although somehow they still are stating that they are a member to it. I don't, for anyone who's following that issue. Okay, I think we can go on to the next slide now.
It's frozen. Hold on a minute.
Okay.
I'll go back up.
Not moving?
Oh. Why don't you
Yeah.
proceed? I'll work on it.
Okay, so why are sanctions important? We know the sanctions have been around for a long time. They're used a lot. There's an agency that deals with them. They coordinate with other agencies, countries, intergovernmental organizations. But so what? What is important about U.S. sanctions? Why am I here talking about this today? Why are you listening to this? And what do you need to know? Well, I want to spend a little bit of time on that issue and figure out why this topic in this webinar is so important. And I think we start with the importance owed to compliance obligations. So this is the first and the most obvious importance. If you fail to comply with U.S. sanctions, there could be consequences. If you're a U.S. person or your transaction involves U.S. jurisdiction somehow, those consequences could be civil penalties or they could be criminal prosecution and imprisonment. But even if you're a non-U.S. person, you're acting completely outside the U.S., and you're acting completely outside the U.S., there's still a possibility of being targeted by sanctions yourself. And those consequences are not just theoretical. As I noted earlier, almost every day there's a news story of some sort of sanctions action against a non-U.S. person. A lot of those involve banks who have paid hundreds of millions or sometimes billions of dollars for and penalties for violating sanctions. You might hear stories about a sanctions evader being extradited to the U.S. to stand trial for those violations. And then, of course, there's new persons being sanctioned for providing support and services to other sanctioned parties all the time. So first and foremost, if you don't abide by U.S. sanctions and you're a U.S. person, you're in violation of the law. But even if you're a non-U.S. person acting outside the U.S., you yourself can become a target. And we'll talk a little bit more about that as we go on. There's also the use of sanctions and their importance as a U.S. foreign policy tool. And I once heard a former OFAC official state this, and it always stuck out to me. But they said that when they conceive of a sanctions program, it's to advance their policies, not to account for every scenario that could occur. I think we're back up on the slides. Great. And so that always stuck out to me, and it kind of underscores the importance of discussing the policy underlying a sanctions program. As I mentioned before, for better or worse, these sanctions programs are now the go-to solution for all U.S. foreign policy issues. Iran's threatening shipping in the Persian Gulf, sanction some elements of its military. You don't like Chinese treatment of the protesters in Hong Kong? Sanction Chinese officials involved in the response. You don't like the way an election was handled in the DRC? Sanction the election officials. U.S. foreign policy these days, and not to be critical, but let's call it for what it is, U.S. foreign policies is a very much sanction first, ask questions later policy. That's what it's become. And I think that's also important to understand broader geopolitical relationships. If you're a sanctions watcher like I am, it becomes easier to predict which countries the U.S. is aligning itself with and which areas of the world the U.S. will become more confrontational with or engaged in. So if you're a sanctions compliance professional, why do you care? Why do you need to know that? Well, you need to forecast. And you need to forecast, are there going to be sanctions in the future in an area that you're operating or with parties you're operating with? So a lot of the due diligence stuff we talk about later in this presentation will kind of consider that forecasting. And because as you know, there's dialogue on new sanctions or as new U.S. sanctions are coming to pass, that dialogue and those new authorities can act as an effective weather vane in determining which parts of the world the U.S. is focused on and which parts of the world might be impacted by new U.S. sanctions. I think, Kay, yeah.
I have a question here.
Yes.
Given the breadth and the complexity of the sanctions regime, over the past few years, there's been various studies that have challenged the effectiveness of sanctions in advancing the stated goals. From your perspective as a practitioner, what do you see as the impact of sanctions? Is it doing, the regime doing what it's supposed to do, or is it failing in some way?
Sure. I think we need to first clarify that impact or impactful and effective or effectiveness are not interchangeable. So in terms of impact, I think that sanctions can be incredibly harmful to their targets, as well as those closest to them or employed by them, et cetera. The irony here is that sanctions proponents have called for the use of more limited, strategically deployed sanctions to kind of dull the negative effects of country-based comprehensive embargoes, which was formerly the sanctions tool of choice in the past, that even those targeted sanctions have broad ancillary consequences. So while you might not see millions of people impacted by a particular sanctions action, you can still see thousands and sometimes tens of thousands of people impacted. So when you designate a business magnet in a foreign country, for engaging in some sort of sanctionable conduct, sure, they might lose access to their bank accounts and they might be personally impacted, but what about all the people working for them? And we've seen, because we represent people who have been listed, we've seen thousands and sometimes tens of thousands of people put out of work and economies really harmed just because of an action taken against one particular person. Now, if we're considering impact in terms of effectiveness, it's really hard to say, because there's certainly cases where sanctions have played some part in causing parties to change behavior, separate from certain relationships, divest themselves of certain assets or dealings. But there's also many cases where sanctions targets, whether they're a government, an organization, or a company, can weather that impact and continue whatever course of dealings led to the sanctions on them in the first place. And I mean, take a look at Iran. Like I said earlier, Iran has been under some form of sanctions really since the late 1970s, but comprehensive country-based sanctions since the mid-1990s. Obviously, the Cuba example speaks to this as well. The Russia sanctions were put into place. It's been over 6 years now. So if the target can weather the effect of the sanctions, then they really, or the impact, then they're really not effective. So if we're equating impact with effectiveness, we need to take a look at each usage of sanctions on a case-by-case basis.
Okay, you ready for the next slide? And we'll go to categories.
Sure.
There we go.
All right, so let's discuss the distinction between the different categories of sanctions programs. So we're going to be talking about here is primary sanctions, secondary sanctions, sectoral sanctions. You might have heard of some of these terms being used, but also country-based embargo versus targeted or limited sanctions programs, micro sanctions, which you might not have heard of before, but I'll discuss what I mean by that. And in discussing these various sanctions programs and types of sanctions, we'll be taking a look primarily at the, no pun intended, primarily at the primary sanctions, derivative sanctions, and the secondary sanctions. Let's start with primary sanctions and country-based embargoes. There is a lot of confusion about what a primary sanction program is. I don't think there's any agreement even amongst sanctions practitioners, whether they're legal practitioners or academics, as to what primary sanctions mean. What I've always understood them to mean, and what those in my office, who include a number of former OFAC officials, understand them to be, is that primary sanctions refer to those sanctions that target particular countries or persons and impose restrictions on dealings by U.S. persons with respect to that particular target. That said, it's not necessarily the nature of the target that renders the targeting primary in nature, but rather the nature of the conduct addressed and the person subject to the consequences of the targeting. Some people disagree with that. But that's the way we've always understood it, and that's the kind of way we look at it. And really, when you get into the practice of sanctions, it doesn't matter whether it's a primary sanction or secondary sanction. These are all terms of art to describe the basic point that a person has been targeted for some conduct and there's restrictions on certain people in dealing with them. Turning to comprehensive sanctions programs, these typically focus on countries and impose blockings or virtual bans on all dealings with that country or the government of that country and those ordinarily resident in those countries. Some common examples of comprehensive sanctions and programs include those targeting Cuba, Iran, Syria, and North Korea. And Cuba is particularly interesting here because, as you may recall, or as you may have heard rather, the sanctions program is promulgated under the Trading with the Enemy Act. And the Trading with the Enemy Act imposes a wholesale blocking on its targets. So there's a wholesale blocking on Cuba and Cuban nationals. And while we're most familiar with the Cuba and the Iran embargoes, due to their virtually complete scope and the length of time they've been imposed, there are other embargoes that are also relevant to understand, even if the need to understand them is for no other reason to know that not all embargoes are the same. So for example, the Syria sanctions program constitutes almost a virtual ban on dealing with Syria. However, it doesn't prohibit imports of Syrian origin goods or services other than those that relate to Syrian origin petroleum or petroleum products. So therefore, you have a country-based embargo, but it's more limited in scope than, for example, the Cuba or the Iran sanctions embargoes. Further, you'll see some country-based embargoes that are not country-specific at all, but rather regional embargoes. So for example, the sanctions prohibiting virtually all transactions with the Crimea region of the Ukraine is a very good example of that. So moving on to targeted and derivative sanctions, what we're going to be talking about here is what some people refer to as limited sanctions programs. And these can often be styled with the name of countries from which the national emergency leading to their issuance emanates. However, these programs are targeted, list-based sanctions, which identify specific targets engaged in conduct rather deemed sanctionable by a particular executive order or statute. So what do I mean here? For example, there is a sanctions program targeting the Democratic Republic of the Congo. That is not a country-wide embargo against the DRC. There is also, it identifies certain parties that are involved in certain types of conduct in the DRC, but it's not a prohibition on US persons dealing with the DRC. There's also sanctions targeting South Sudan. Again, not a virtual ban on dealing with South Sudan, rather there's certain parties there that you can't deal with. So don't get confused by that use of a country's name to describe a targeted sanctions program. There are also limited sanctions programs targeting specific identified conduct, such as counterterrorism sanctions, non-proliferation of weapons of mass destruction sanctions, and counter-narcotic sanctions as well. Within this set of sanctions, you have derivative sanctions authorities. Okay, so you have limited sanctions, but then there are sanctions authorities from which designations derive from a target of the limited sanctions action. So what do I mean? Derivative sanctions are those sanctions which are imposed due to some relationship between a party targeted under the sanctions authority and the person upon which the derivative sanctions are being imposed. So for example, derivative sanctions are those that are applied to parties that are owned or controlled by a particular sanctions target, acting for or on behalf of a particular sanctions target, or providing support or services to a targeted party. In other words, the sanctions derive from the relationship as opposed to just the conduct of the derivatively sanctioned person alone. And so what you'll see a lot of times is a sanctions target be designated, and then a number of companies that they own be designated as well, or other individuals who may be providing support and services to that sanctioned target. So it's important to keep in mind, if you're dealing with a sanctions target, or if you become targeted yourself, unfortunately, it could not be, it could be the circumstances are that you were designated due to your relationship to a particular target and not necessarily for your own particular conduct. So keep that in mind. And then further, just one quick note on OFAC's 50% rule, since we're on the subject of derivative sanctions. If you've heard of the OFAC, or if you haven't heard of the OFAC 50% rule, what it does is it imposes a blocking on corporate entities that have not been specifically identified and designated by OFAC if the ownership of that corporate entity is held 50% or more in the aggregate by blocked persons. This is to ownership only. So at least generally speaking, if you can determine that blocked persons control a particular entity, but that ends, let's say through directorships or officers, that doesn't automatically block the entity, except in certain cases. But ownership alone would, under OFAC's 50% rule, block the entity despite no specific identification or designation of that entity. That said, I want to note that there are some new sanctions authorities, and I'm thinking of Executive Order 13884 specifically. That's the authority blocking the government of Venezuela, that does appear to block entities controlled by the government of Venezuela, and that determination appears to be in the hands of, at least in certain instances, in the hands of the private sector. That's outside the OFAC 50% rule, so it's different than what I'm talking about here, but we have seen that kind of creep into recent sanctions authorities, so be wary of it. Let's talk a little bit about secondary and sectoral sanctions. So under this umbrella of limited sanctions programs are sectoral sanctions programs, which are list-based, and in some instances can be limited in the scope of their prohibitions. Sectoral sanctions really came out came into vogue rather with the Ukraine-related, Russia-related sanctions programs. So they get confused or kind of lumped in with this idea of micro-sanctioning, which I'll talk about in a moment. But really, what's important to note here with the concept of secondary sanctions is it involves, and sectoral sanctions, is that it either involves the imposition of sanctions for not being directly engaged in an activity that's material for that which is being targeted, but significant with respect to targeted persons, or in the sectoral sanctions conduct operating in certain targeted economic sectors of a particular economy. So, for example, operating in the oil sector of the Venezuela economy by transporting oil to and from Venezuela would be a sectoral sanction. They're not interchangeable, but they are used a lot together, and that's why I kind of put them together on this point. I note here that derivative sanctions are often confused as secondary sanctions. Again, like I said, there's a lot of debate amongst sanctions practitioners about the appropriate terms of art are. But the key point here is not to get tripped up on that. Just keep in mind that issue of materiality versus significant transactions. Secondary sanctions can be imposed merely for engaging in significant transactions with a target, absent any materiality to the conduct targeted by a particular sanctions program for which that party was targeted. And I know that wasn't the most wieldy way of saying that, but just keep in mind materiality versus significant transactions. All right. I don't know, Kay, did you have any questions there that you wanted to ask, or should I move on to the next point?
No questions yet. Okay.
Well, let's talk a little bit about blocking sanctions then. We've discussed categories of sanctions. Let's talk about types of sanctions. First, the most common type of sanction is a blocking, also sometimes referred to as an asset freeze. In short, this type of sanction blocks all interests in property that are targeted, that the targeted party has an interest in, which come into U.S. jurisdiction, meaning within the United States or within the possession or control of a United States person. So what's most important to keep in mind here are the jurisdictional requirements. And one of the biggest sources of confusion surrounding sanctions is what is actually prohibited. And I kind of mentioned this when we were beginning the presentation, but what subjects a person to civil or criminal liability versus what exposes a person to a sanctions designation. So to understand that, and to understand where that line is, there needs to be an understanding as to whether the activity falls within the jurisdiction of the United States. And that analysis requires taking a look at whether there are any U.S. persons involved in the transactions. Are there any goods or services supplied from the U.S. or by U.S. persons? Or is there some other nexus point involving the U.S.? And I keep using this term U.S. person, so let me give you at least a traditional definition of U.S. person. In the sanctions context, what we're talking about is U.S. citizens and U.S. permanent legal residents located anywhere in the world. Anyone physically present in the U.S., so say there is a person who's in the U.S. on a visa, they are now considered a U.S. person for purposes of sanctions laws, or any entity formed under the laws of any jurisdiction of the United States and their foreign branches and affiliates. In some sanctions programs, that jurisdiction extends to U.S. owned or controlled foreign subsidiaries as well. So for example, Iran, but I don't want to go too far into the weeds on that because of restrictions on time. So this sounds maybe pretty simple to you, but it's not as easy to figure out as it appears. And this is for a number of reasons. First, there's this concept of causation within U.S. sanctions laws. And what causation means is that if you're a foreign person and you're acting completely abroad with respect to a transaction with a sanctioned person or a sanctioned jurisdiction, you could still engage in an activity that somewhere along the lines implicates the involvement of a U.S. person, U.S. services, U.S. goods, etc., even if you were unaware of the transaction or that the transaction would have such an implication. This type of causation liability occurs all the time. So for example, let's say you're a Turkish citizen, you're in Turkey and you're remitting a payment of 10,000 euro from your Turkish bank account to the account of an Emirati charity held at a local UAE bank. The Emirati charity is owned 50% by an organization designated under Executive Order 13224. That's the counterterrorism sanctions. The payment, which is going to be cleared from Turkish lira into euro, clears through Citibank London, which is a foreign branch of Citibank US. Citi London flags the transaction, discovers that the charity is blocked pursuant to OFAC's 50% rule and blocks the payment. You, the Turkish citizen, as the remitting party, have now caused the violation of the global terrorism sanctions regulations, which brings you under US jurisdiction and can render you civilly and criminally liable for that payment. You might have heard of this case, US v. Zarab. It was a big sanctions evasion case out of the Southern District of New York. It's actually still going on. But that type of liability is similar to the liability imposed upon the defendants in that case and for which they were prosecuted. And if you do know the case, or you don't know the case rather, there have been multiple convictions under that theory of liability. So that shows how you as a foreign person thinking you're acting completely outside of the US can implicate US sanctions and become civilly or criminally liable. I also want to take a minute to talk about what an asset freeze is or isn't. It's not supposed to be a seizure. A blocking is supposed to be a freezing of assets, not a seizure and potential forfeiture of those assets. At least that's what the government purports the intent to be. Courts have generally accepted this position, although there has been some skepticism by courts as to whether a blocking can never be considered a seizure. So for example, if the blocking goes on for an inordinately long period of time, there's an open question mark. Has that now become a seizure? Also, in some sanctions programs, the assets of parties blocked under those programs have been subject to attachment and forfeiture to satisfy judgments against certain organizations that have been held civilly liable in US courts for act of terrorism. So what do I mean here? US has designated a particular organization as a foreign terrorist organization. Plaintiffs' lawyers go in representing a class of plaintiffs that have lost family members or otherwise been harmed by foreign terrorist organizations. OFAC designates someone alleging that they provide support or services to that foreign terrorist organization. The plaintiffs from those cases that have brought the civil lawsuits against the foreign terrorist organizations then go and seek to attach the assets that have been frozen or blocked belonging to that third party that designated third party. So I know that was it's kind of complicated, but it just shows you that although this is supposed to be a blocking and a freeze, that sometimes it turns into a seizure and forfeitures occur because of the interplay of other laws and other actions that are occurring. So keep that in mind, because there are circumstances where blocking actions go beyond the intent of just a simple asset freeze. Now, if you're dealing with a blocking of property or property interests, it's important to note a few things. First, you can't deal in that property in any way without an OFAC license authorizing those dealings. It could be a specific license, it could be a general license, it could be an authorization incorporated into the regulations, but you need some sort of authorization from OFAC to act with respect to that blocked property. Finally, further, if an account is blocked, the property should typically be blocked in an interest-bearing account. So what happens a lot of times is bank blocks the funds, moves it into a separate account that accrues interest until such time as OFAC either licenses the unblocking of the property or the target for which the blocking was undertaken has been removed from the sanctions list. Finally, there's certain reporting requirements that come into play with dealing with blocked property. Specifically, any U.S. persons in possession or control of blocked property have a legal obligation to report that blocked property to OFAC within 10 days of the blocking. Moreover, those persons will be required to file annual reports to OFAC concerning the status of the blocked property. Please note here that there's also a difference between blocking a transaction and rejecting it. So as I noted, blocking a transaction is appropriate in the event that a blocked party maintains an interest in the transaction, or, for example, in the case of Cuba, if a Cuban national maintains an interest, or if the transaction otherwise relates to Cuba. However, in certain sanctions programs, Iran, Syria, Crimea, for example, if there are not otherwise blocked parties involved in the transaction, then the appropriate course of action is to reject the transaction. In either scenario, blocking or rejection, a report has to be filed with OFAC within 10 days after that blocking or rejection. Kay, I don't know if you have any questions on that, or I should move along to the...
I think we've got 4 questions up here.
Okay.
There's a question about, thank you for clarifying U.S. person, but how do you define U.S. goods? What about electronics containing components by an American company?
So that kind of previews the next area I'm going into, which is the trade restrictions. So I think I'll address that when we get into that, but that is going to be covered momentarily. Was there another question?
There's another one. How is it true that transactions for humanitarian aid and communication-based equipment still are prohibited, even if there are some regulatory exemptions? And I think this is in relation to the Iran case above, based on official U.S. statements and some regulations. Transactions for humanitarian aid and some communication-based equipment are said not to be subject to sanctions, even secondary. But these exceptions and exemptions don't work because of the financial mechanisms, the banks that still do not provide ratings with the required services for these transfers.
Right, and so that's going to be a whole nother section that we're going to get into as well. So we'll talk about that a little bit later. So maybe if there's another question, I just want to make sure we don't duplicate our efforts here. So, but I do intend to answer both of those questions.
Okay, yeah, let's move on to sanctions consequences.
Yeah, I think actually we still got one little bit of background on miscellaneous sanctions, which I'll go through quickly. Trade restrictions are another type of sanctions, and they're very common. It's very common for U.S. sanctions authorities to prohibit transactions or dealings. And what this generally means is that there can't be any exports or supply by U.S. persons of goods, technology, or services to sanctioned persons or those physically present, ordinarily resident, or ordinarily resident in those sanctioned countries. These prohibitions also generally include no importation of or dealing in goods or services from those parties or countries either. So it was a virtual ban on transactions. I talked a little bit about causation before, so I won't reiterate that point, but I want to talk about another concept in U.S. sanctions programs referred to as facilitations. And sometimes facilitations fall under evasion, depending on the sanctions program and how OFAC has used those authorities. But what facilitation is, you understand causation is causing a U.S. person to engage in the violation. Facilitation is a prohibition on U.S. persons undertaking some act that allows foreign persons to engage in a transaction that would be prohibited were the U.S. person directly involved. So let me give you an example of what that means. Someone calls me from Iran. I'm a U.S. person. They call me from Iran and they say, I want to buy spark plugs from you. I said, well, look, I can't sell you spark plugs, but I work with this distributor in Germany, and I'm going to refer the sale to the distributor in Germany. And then I make that business referral to that distributor, and the German party and the Iranian party begin to transact with one another. I've actually violated U.S. sanctions because I facilitated that transaction by making the referral, for example. So that's kind of the inverse almost of causation, where you have, under causation, you have the foreign person causing the U.S. person to engage in the transaction, whereas in facilitation, you have the U.S. person causing foreign persons to engage in the transactions they otherwise couldn't have engaged in. So that's, outside of these export and import bans, it's important to understand these two concepts of facilitation and causation. I think it's also important to understand attempt. And what attempt is, if you take any act towards the commission of a transaction, that would be a violation. So for example, if someone orders parts from you for export to Iran, you know, that someone in Iran says, I want to buy those spark plugs from you, and you enter into a contract, but you never fulfill the contract, entry into that contract alone is an attempt, and therefore technically a violation. Whether or not OFAC, you know, would penalize you or you would be prosecuted for it is a separate issue, but technically that would constitute violation. So let's actually talk a little bit about the goods question that was just asked. It's not just U.S. persons, not just U.S. services, but also U.S. origin goods, but also foreign-made goods that incorporate certain levels of U.S. origin content. And there are different thresholds here depending on which sanctions program you're relying on, and those thresholds go from anywhere from 10% to 25%. And you need to examine those on a case-by-case basis. Typically, those are complicated questions, and you might need some export control advice or guidance as well when looking at it to determine whether or not the de minimis threshold is met. But there can be cases where you have a foreign-made good that incorporates, you know, a certain amount of U.S. origin technology or components or parts, and it transforms that foreign-made good, at least from a U.S. Perspective, into a U.S. origin good. So you need to take that, needs to be reviewed case by case, take a look at the particular sanctions program and understand how to calculate the de minimis value. Also, I think another point to note here is that once a good passes through a sanctioned jurisdiction stream of commerce, that renders the good to be of origin of that sanctioned jurisdiction, and therefore potentially prohibited to deal with respect to. And I remember this coming up in a case a number of years ago, a criminal prosecution, where there was a non-US person in Dubai that was purchasing, I think it was Toshiba laptops, and re-exporting them to Iran. And one thing my client couldn't wrap his mind around, he's like, well, wait a second, these are Japanese, I believe it was Japanese laptops, and I'm in the UAE and they're going to Iran where there's no US nexus. And the US nexus actually occurred, as I guess a little bit different than what I was just talking about, but the US nexus occurred when it passed through the United States because it was sold by a US distributor. But likewise, if it were the other way, and it was Japanese laptops being sold by an Iranian distributor to the US, it would become an Iranian origin good because it's passing through the stream of commerce there. So there's a lot of interesting issues, and that was a very good question about the origin of goods and what's US origin, what's foreign made, what's a good of an origin of a sanctioned jurisdiction, et cetera. And those are very complicated questions. I also want to talk about CAPTA sanctions. These are correspondent and payable through account sanctions. The reason why I think they're relevant here and kind of speak to one of the questions we're just asked is this is one of the big things that scares foreign financial institutions from processing any transactions where there's sanctions implications, even where there's authorizations for those transactions to move forward. Captive sanctions are traditionally secondary sanctions. Sometimes they're sectoral in nature, and they pose restrictions on foreign financial institutions that have been determined to engage in or facilitate certain types of significant transactions on behalf of targeted persons or targeted activity. And these prohibitions are those placed upon U.S. persons in opening or maintaining correspondent banking relationships on behalf of these identified foreign financial institutions. In practice, what this really means, if a foreign financial institution has been determined to have engaged in those transactions and has captive sanctions in place upon it, those foreign financial institutions will not have access to the U.S. Banks or U.S. dollar clearing. So that's why it's so devastating. And although you don't see a lot of captive sanctions actions, there is quite a bit of concern from foreign financial institutions with respect to those. I'm going to go very quickly through micro sanctions because we've already talked a little bit about sectoral sanctions. All micro sanctions means are limited types of trade prohibitions on dealings with targets. So in the Russia case, for example, you have sectoral sanctions on persons who are operating in certain sectors. Let's say it's the financial services sector. Micro sanctions are applied, meaning they're only prohibitions with respect to certain types of dealings. So, for example, dealings in debt where the maturity date is within longer than 14 days, dealing in new equity issued by the target, et cetera. And I don't want to spend any more time on that other than say this shows that there's a tailoring of sanctions use depending on the targets being identified, how integrated they are into global markets, and that the impact the designation and the prohibitions would have on the broader global economy. So I don't want to spend any more time on that because I think we're already a bit behind schedule. So, Kay, should I move on to sanctions questions or?
Let's move on to the consequences.
Okay, let's talk.
We can do more questions after that.
Okay, sounds good. Let's talk about the enforcement process, how the enforcement process unfolds. It's actually pretty straightforward. Treasury gets information from somewhere, whether it's a financial institution that's filed a blocking report, whether the FBI or some other law enforcement or intelligence agency has passed information on to them, whether it's been provided in a submission by a private party to OFAC, so on and so forth. They take the information and they can open an investigation. And typically what they do is they issue what we call administrative subpoenas, or sometimes you'll hear them referred to as 602s to different parties to gather information regarding certain relationships or certain transactions or activities that party has engaged in. So any person who has engaged in a transaction that implicates U.S. sanctions is required to keep records for 5 years, and OFAC can compel records with respect to those transactions for 5 years, and OFAC can compel disclosure of that information under its authorities. So they'll issue the subpoena, you'll have to respond. OFAC will then take that information and they'll determine whether or not they want to engage in an enforcement action. And there's 5 enforcement actions OFAC can take. One, they can issue a no action letter, which says, okay, we're not doing anything about this. 2, they can issue a cautionary letter, which says that, okay, there appears to have been a violation, but we're giving you a warning. 3, they can issue a finding of violation, which is a public declaration that you engage in a sanctions violation, but that there's no corresponding civil penalty. And they can also engage in a civil penalty. If they do that, they will first issue a pre-penalty notice that says, okay, this is what we're thinking about giving you in terms of penalty. You have an additional 30 days to respond to that notice to argue why you should either not get a penalty or the amount should be mitigated. And then 5, and the most extreme, is that they can make referrals to the Department of Justice for criminal prosecution. Criminal prosecution occurs where there has been some evidence of willfulness, that you as the party engaged in the violation knew what you were doing was a violation, but you did it anyways. OFAC assesses and we could have a whole talk on how OFAC assesses penalties. I'm not going to go into it, but here's what's important to know, that there is a set of guidelines called OFAC's enforcement guidelines. The OFAC enforcement guidelines set forth a matrix on how to calculate a base penalty. Those base penalties take a look at really 2 criteria. 1, how egregious was the conduct? And 2, did you voluntarily self-disclose the conduct, or did OFAC find out about the conduct itself? So, and then you'll calculate a base penalty from there. Once OFAC has determined a base penalty amount, they will apply the general factors affecting administrative action. So there's factors A through K that OFAC will consider when reviewing an enforcement action to determine whether to aggravate or mitigate the enforcement response. And so some of the things they look at are, was there reckless behavior? Was any kind of management involved in the apparent violation? What was the awareness of the conduct? Is this something you knew going into it was going to happen, or did this kind of happen due to some, glitch in the software, for example? Did the party maintain a sanctions compliance program? What has the party done to remediate the conduct so it doesn't happen again? OFAC considers all those things in determining the proposed penalty when going through this enforcement process. And then the penalty amounts, there's penalty amounts all the way up to criminal prosecution, and those criminal prosecutions, depending on the sanctions program, can be up to 30 years imprisonment. The civil penalties is what most people are concerned with, and those numbers recently changed in April. So to give you, as of April 9th, the maximum penalty under sanctions programs issued under the Trading with the Enemy Act was $90,743. Under IEPA, it was $307,922. Under EDPA, which is the Anti-Terrorism Effective Death Penalty Act, that's dealing with foreign terrorist organizations, it's $81,000, and their agents, $81,283. Under the Foreign Narcotics Kingpin Designation Act, that's the primary counter-narco program, so $1,529,991. And I think those are the main ones you need. Those are the big 4 you need to know. But the point being here is that these are very high penalty amounts, and they've recently gone up. And these are per transaction. So this isn't, everything together that's as high as they can go. This is for every transaction. Every transaction that was a violation, they can go up to that amount. Let's talk a little bit about designation, targeting of parties. Again, pretty straightforward. OFAC is the aggregator of information from a variety of sources to determine whether or not a party meets the criteria under a particular executive order or statute for designation. So OFAC will get information from law enforcement agencies, from intelligence agencies, including other components of Treasury and some of its sister agencies, and they will take that information and determine whether or not there is a factual basis and a legal basis to designate that party. A couple of things to keep in mind here. In order to designate a party, OFAC only needs to have a reasonable cause to believe that the party meets the criteria. This is one of the lowest standards in our legal system. It is not beyond a reasonable doubt like you have in a criminal prosecution. It's not even probable cause. It's not preponderance of the evidence. Do they have a reason to believe the information they're looking at is true? Does that, if the answer is yes, does that information evidence sanctionable conduct? Yes, then okay, they can designate you and that's all they have to do. Their evidentiary standards are pretty much non-existent. OFAC can rely on anonymous tips. It can rely on hearsay statements. Oftentimes when we're challenging these designations, we see, someone wrote something on a blog and OFAC relies upon that information in the blog. So OFAC kind of, and no one chide them too much here, but they take, a lot of pride in the strength of their designation packets and how much information they gather, but they really don't have any evidentiary standards. The courts have said that as well. And their legal standard is very low. It's reasonable cause to believe. And let me add one more layer to that, which is when their actions are being reviewed, typically they're being reviewed under the Administrative Procedure Act, which says that the court will only overturn a federal agency's action if it's deemed to be not in accordance with the law, fail to observe some legal procedure, or arbitrary and capricious. And what the courts have said in making those determinations under the arbitrary and capricious and the other APA standards is that OFAC's fact findings are afforded extreme deference. So basically, the courts generally just accept whatever OFAC is saying. And if they're accepting what OFAC is saying and they can reasonably understand how they came to that conclusion, they don't need to agree with the conclusion, only they can see how they got to it, then the court will uphold the propriety of that designation. So this is, once you get targeted, it's very difficult to come off for all of those reasons. The standards are low across the board, and the courts generally just defer to whatever OFAC says. The impact of the designation can be devastating. I talked a little bit about that earlier. You can have thousands, tens of thousands of people impacted by one person's designation. Generally, this means that person is locked out of the the financial institution, not only the U.S., financial institutions, not only in the U.S., but also in their home country. You see that a lot. They become kind of an international pariah. So very impactful. Not sure about effectiveness, but very impactful. Delisting, just one quick moment on that, is very difficult. You have to show that either OFAC made a mistake, they're not in the business of admitting mistakes, or you have to show a change in circumstances, meaning, okay, OFAC, we're not going to argue with you about whatever finding you made before, but here's why, as of today, the circumstances do not support the designation and will not support the designation moving forward. And I'm going a little bit quick here because I do want to make sure we get to your questions, and there's still a lot to cover. So I apologize for kind of the brevity I'm giving some of these topics. Practical consequences, reputational. It's very hard to ever overcome a sanctions designation, even once you're delisted. That material underlying that was kind of circulated at the time of the designation stays online. People find it, even if you've been removed. People generally, counterparties generally don't want to deal with you. So it's been called an economic death penalty. I think that's an extreme term, but maybe not entirely unfair. It's really harmful to your reputation and has long-standing harm even after a designation is removed. Also, there's consequences overseas. As I mentioned earlier, foreign financial institutions in a country typically won't deal with you, even if don't have any other U.S. nexus. They just don't want to deal with parties who are sanctioned, period. Full stop. We've also seen foreign governments take action against designated persons, for example, by opening criminal investigations against them, arresting them, all based on allegations made by the U.S. in their designation actions. And remember, those allegations are those that are supported by a legal standard that only requires OFAC to have a reasonable cause to believe something, and where there are no evidentiary standards at play, and where anything OFAC says is going to be afforded extreme deference. So you have people being arrested in their home countries based on allegations contained in an OFAC press release that are made subject to those standards we talked about. So, and I apologize if that sounds like sour grapes to you, but it is an issue I deal with every day at work. So it's one that is near and dear to me. Maybe not dear, but definitely near to me. And then you have this issue of over-compliance, and this is kind of alluded to by one of the questions we got earlier. Banks just don't want to deal with any kind of sanctions problem, even if it's exempt, even if it's authorized. It takes a lot of effort by the bank to figure out, what's going on. Being sure of what's going on is never guaranteed. They could get it wrong. Sometimes the banks aren't even worried about OFAC. They're actually worried about undertaking a transaction that would be authorized under the sanctions, but which presents a higher level of risk. And therefore, they might get scrutiny from their own local regulators as to why they're incurring that kind of risk. And the financial gain to be made from processing those transactions for them is, quite frankly, very limited. So banks, even where there's authorizations available, they're looking at it as, this isn't worth it to us. We're going to have to spend so many man hours figuring this out, where there's going to be risk no matter what we do. And even if we get everything right, our local regulators might say, hey, what are you guys why are you guys doing this? This is a risky proposition. And then they have to answer there. So there's a lot of factors here that go into overcompliance, but overcompliance is a real thing that arises out of sanctions actions. And those are the reasons why. Kay, I don't know if you have any other questions before we move on.
I have one, and it looks like we have one on the list too. This designation process has been a particular concern to the U.S. charitable sector because, as you know, between 2001 and 2009, OFAC listed 9 U.S.-based charities using this process. And it was effectively a death penalty for those organizations. But in 2 cases, and the most recent ones, the federal courts found the constitutional problems with the designation process as it applied to these U.S. charities. What were those constitutional issues, and has OFAC changed its process as a result of these court rulings?
Sure. I think the cases you're referring to are the Al Haramain and the Kinehart cases, which in both cases, the courts found that there were due process violations that occurred because OFAC was withholding information as to the reasons for the designation, which prevented those charities from having a meaningful opportunity to respond to the basis for their designations. There was also some discussion, at least in Kinehart's, about the blocking potentially being an unreasonable search and seizure in light of the Fourth Amendment. Ultimately, those constitutional violations were addressed either through the disclosure of more information or through other means, for example, unclassified summaries of the classified information. As someone who deals with a lot of delisting cases, it's very hard to get information from OFAC. They keep that information from you. OFAC hasn't changed its rules in light of the court's rulings in those cases. However, I think they have changed their practices. They do more routinely provide unclassified summaries in designation actions. I think they're a lot better about communicating the reasons for a designation than they were maybe in the 2000s. But I would note too that those 2 cases dealt with constitutional rights and violations of constitutional rights because the charities involved were US-based charities. But most parties designated by OFAC are not in the US. And the courts are increasingly becoming more express that foreign nationals with no connection to the US cannot assert constitutional rights.
Right.
So, you know, that's a problem for foreign charities who might be designated. They might not be afforded the same level of protections or granted as much latitude from the courts.
We have another question here asking what percentage of success does OFAC have? I would think, I'm not sure if that refers to enforcement action or effectiveness action, or what effectiveness do people have maybe with attempts to delist?
Sure. Well, I just ran the numbers recently on delisting. So our firm right now is at about 70%, a little bit less than 70% success rate in delisting parties. Now, that's not because we're amazing. It's because we kind of know the process and we know what needs to happen in that process. I don't know if there's any general numbers for how many parties apply for delisting and are delisted. I don't know, but here's what I do know. OFAC does delist parties. There is a process to do so. And if you follow that process, most of the time, then you can be delisted. With respect to how successful OFAC is in its designations, I guess maybe there's a way to address that, which is how often are they right? There's thousands and thousands of people on the OFAC list. My understanding is that there's only dozens or maybe even a couple hundred that challenge their designation. So a lot of these go unchallenged. So if that gives you any indication on how often they're giving it right, I don't know. I don't know if that's the most scientific method for figuring that out. In terms of enforcement, OFAC, I think because of the way it picks and chooses its enforcement cases and the way it announces those enforcement cases, has been pretty effective in getting the private sector to comply. How many cases kind of fall by the wayside, I don't know, but I definitely know of OFAC case investigations that started and the statute of limitations ran out. So, they weren't successful there, but I think they've done a good job, at least in furthering their mission by in their enforcement actions and how they pick those cases and publicize them. So I think that answers the question, but.
Yeah, let's move on to humanitarian exemptions, because I know this is an area of very high interest to our members and our audience.
Sure. Okay, so let's get into that. First, I want to note there's IEPA-based exemptions. Okay, so IEPA is the International Emergency Economic Powers Act. That's the primary sanctions authority, and so you have an exemption built in there itself, which exempts, and what that means is it removes from the president's authority the ability to regulate donations of articles, and then there's a comma there, and I'll talk a little bit about what that means in a minute, but donations of articles, comma, such as food, clothing, and medicine, comma, intended to be used to relieve human suffering, except with certain determinations are made. For example, if it would undermine effectiveness of the sanctions or harm U.S. armed forces. These exemptions, or that exemption in particular, are incorporated into most sets of regulations you see. So you have the statutory authority exempting from the president's authority. The executive order can't go beyond the statute. The regulations can't go beyond the executive order. But typically what OFAC does, or what the sanctions programs do, is they take the IEPA-based exemption if it's an IEPA-based program, most are. They incorporate it into the executive order issued pursuant to IEPA, and then it gets incorporated into the regs. So for example, if you're looking at the Iran program, you'll look at section 560.210, and you'll see that donation, humanitarian donation exemption there. Now, I point out this issue on the comma because I want to talk about limits. It's traditionally been thought of as there are limits. The limits on donations are to food, clothing, and medicine. I think a lot of people kind of purport that that's the extent of the exemption. But I think a plain reading of it actually supports you can donate articles intended to be used to relieve human suffering, and that those articles could include or be such as food, clothing, and medicine. So there is a question mark as to whether a particular article that falls outside of food, clothing, and medicine, but is being used to relieve human suffering, falls under the exemption. So there's a little bit of gray area here with this exemption that maybe calls for a closer look depending on the nature of the article and the particular sanctions program that's being implicated. Okay, I don't know if you had any questions on that or if I should just plow through here. No, I'm not hearing you. I don't know if you've muted, but I'll go ahead and move forward. So there's other exemptions as well contained in statutes, but there's not every statute contains this kind of humanitarian related exemption or exemptions on exports of food, medicine, or medical devices. There is a statute called the Trade Sanctions Reform and Export Enhancement Act of 2000, which basically states that U.S. sanctions shouldn't get in the way of exports of food, medicine, and medical devices and agricultural commodities, but it doesn't necessarily exempt that activity. What it does is that there should be measures taken to allow for those types of exports. So those could be in the form of general authorizations, specific licensing programs, which we'll talk about in a minute, or otherwise. One last point on this exemptions versus authorizations. I know I went through it quickly, but that's, again, for time. Exemptions means that it's outside of the executive's authority to prohibit. Authorizations, general licenses, specific licenses, mean that the activity is prohibited, but that Treasury has used its discretion to issue an authorization allowing for it. So keep in mind here, if you're donating, that's exempt. If you're selling food, that's authorized. That authorization can be revoked at any time. There's also a number of caveats on such authorizations. So be mindful of that. Just one point on this these different terms of art I'm using. You got regulatory authorizations. You have general licenses. Those are authorizations that are open and self-executing. You don't need to apply for a general license. You can just rely upon a general license to engage in a particular category. You have statements of licensing policy. This just means that OFAC has made statements that they will consider on a case-by-case basis certain types of activities. That's usually an indication that they will view those applications favorably, but not a guarantee. And then you have specific licenses where you go to OFAC and you say, we want to engage in the following course of conduct. We believe that it implicates U.S. sanctions. It would be prohibited. So please give us an authorization to do so. You cannot apply for a specific license for activity that is already generally authorized. OFAC will kick back your application. So just keep that in mind, because a lot of people try to do this is they want to get something in writing from Treasury, but a general license applies. So they say, well, we'll just go in and ask for the same thing that the general license authorizes, but in specific license format. OFAC will not issue an authorization there. They'll return without action. Now, what they might do is they might say, okay, items 1 through 4 that you're asking for, those are generally authorized, but item 5 requires a specific license. So here's your license for item 5. But just keep that in mind. Kay, were there any questions there?
Yes, I have 2 on this section.
Okay.
First is on the IEPA-based exemptions, that there is an exemption contained in the statute, but since starting with Executive Order 13224 and the terrorism designations, every one of them has used the President's authority to cancel that exemption, claiming some kind of threat to national security. And so over the years, that's had the effect of repealing the exemption, or at least it's not available in the terrorism designation arena. Is this legal, or what can we do, or what needs to be done to reinstate that statutory exemption?
Yeah, so it is legal, and this is another topic of debate among sanctions practitioners. But the reason for this, in particular with respect to EO 13224, and you see it in other executive orders as well, is that they are issued under a variety of different statutes. So it's not just IEPA. And in the case of 13224, it derives its authority from both IEPA as well as the United Nations Participation Act. And since the UNPA doesn't have a similar exemption, what it does is it effectively nullifies the IEPA-based exemption that would otherwise carry through to 13224. So thus, what can you do to change it? I mean, I think there would either need to be some action by the UN Security Council resolution that would contain a similar exemption to IEPA, or you'd have to have some amendment to the UNPA to carry over IEPA exemptions when the UN actions are where the IEPA exemptions are not contained in the UN action. So that's kind of why that happens. It's not the only, 13224 and counterterrorism is not the only program in which that happens. It happens in other contexts as well.
Yeah. The other question I have is regarding the licensing process, especially the specific licenses, which NGOs often find this to be opaque, time-consuming, and very, very slow in terms of getting a response. And that's more of a general question, but have sanctions become so ubiquitous and complex that the licensing process is becoming dysfunctional? Totally loaded question, but have to ask.
So I don't want to call it dysfunctional, but there's certainly a lot of problems with OFAC licensing. And I would note that it's an area in which our firm is taking on less and less cases that are purely licensing cases due to the fact that it is so slow. And usually by the time OFAC returns an authorization, it's well after the time in which that authorization is needed. So thus, what we tell clients is you're determining whether to pursue an OFAC authorization or to forego some undertaking for which the authorization is necessary. What we tell clients is determine whether you can limit the scope of your activities to those falling under an exemption or an existing general license. And if you can't, we just tell them candidly that they should be prepared to wait potentially for years to get authorization necessary to carry out their proposed activities if they go through the licensing process. We just got a license last week for something we applied for in 2017. So it was over 3 years to get that authorization.
Mm-hmm.
And particularly when you're dealing with these kind of issues where, maybe it's a transaction in relation to like a terrorist organization or a country or area that's really high priority for U.S. foreign policy or national security, things get kicked over to the State Department for foreign policy guidance, and they sit there for a very, very long time. And political winds shift during that time, and they might be gearing up to issue positive guidance, and then something changes, or vice versa. So, yeah, I mean, the process is incredibly slow, and a lot of times not worth it, to be candid.
Well, let's move to the next slide. I know that we're coming up towards the end of the scheduled time, but this is such an important and rich topic. I encourage people to stay with us. If you're unable to, we will be posting this on our website, so you'll be able to get the information later. But,
okay.
Up to the next slide here.
Right. So look, there's a lot of guidance that OFAC has put out in terms of fact sheets, as well as with respect to frequently asked questions and answers on its website. I think the best place to look for guidance, at least from a country perspective, is the recent guidance OFAC put out on humanitarian efforts to combat COVID-19 and the pandemic. It's a very comprehensive fact sheet. It contains, it's about 10 pages: Iran, Syria, Venezuela, Cuba, North Korea, Ukraine, and Russia related. But a lot of the concepts it discusses are broader than just those sanctions programs. So it's a great starting point to understand how OFAC looks at humanitarian efforts, what kinds of exemptions and authorizations exist. And even if you're dealing with a sanctions program that doesn't contain that kind of exemption or general authorization, it's an important place to look to say, okay, we want to do this in this particular sanctions program that implicates this particular sanctions program. You can do it with Iran, you can do it with Venezuela, but it's not spelled out in this particular authority. So let's put in a specific license and make reference to the authorization that contains in those other programs. So it's really useful in that regard. But what's also interesting is it kind of points out a number of licensing policies that are either not found in the regulations or kind of obscured in previously issued guidance. So, and I think the big one here is they note that OFAC will consider on an expedited basis specific license applications seeking authorization to send certain limited categories of items that may be helpful for COVID-19 related assistance on a prioritized and expedited basis. And what we're really talking about here are those items that wouldn't fall under, for example, a general authorization for export of medical devices, but that would require specific license authorization. And they provide some examples. So for instance, they say oxygen generators, full face mask respirators, including powered air purifying respirators, certain types of diagnostic medical imaging equipment, and certain types of decontamination equipment. Again, that's for medical devices that are not already falling under general license. And they also noted, and this has been stated other places, but that they do consider license requests on a case-by-case basis and prioritize applications, compliance questions, and other requests related to humanitarian support for the people of Iran, Venezuela, North Korea, Syria, Cuba, and Ukraine. So if you're operating in one of those jurisdictions and you have questions or you need authorizations, at least now OFAC has put in writing that they will consider those on a prioritized basis. I'm not saying you're going to get it quickly. I'm just saying that you can at least point to something to OFAC to say, hey, please prioritize this. As I mentioned before, there's a variety of different humanitarian guidance out there. There's October 2014 guidance that was issued to NGOs. So that's been on the books for a long time. And really what that guidance gets into is the reach of economic sanctions for those non-governmental organizations involved in providing humanitarian assistance. So it's been, and what they say there, it's their longstanding policy to use licensing authority to support humanitarian relief efforts. I know maybe some people on this webinar won't share that view, but at least that is what their stated intent is. And it notes a favorable specific licensing policy, which you might remember I just made reference to that term a moment ago with respect to the provision of humanitarian assistance, especially in countries subject to comprehensive sanctions. And again, there's a reiteration of that prioritization for requests for licenses, and OFAC endeavors to review those expeditiously. I think it also is important to note that it sets out that non-US persons who can't avail themselves of a particular exemption or general license may also, I don't want to say be exempt, but the likelihood of designating an entity who's providing supported services that a US entity would be exempt or generally authorized to provide themselves would not necessarily be targeted by OFAC. So that's a useful guidance to refer to. A lot of it is policy driven, but it's good to make reference to that, particularly in license applications being made to OFAC. There's a good Iran guidance from 2013 as well. It kind of delves into some of those same issues. And Iran is interesting because you actually have a wide variety of general authorizations. You have the IEPA exemptions, so on and so forth, and guidance from OFAC on humanitarian efforts that can be made with respect or undertaken with respect to Iran. But you also have a high prevalence of parties that are designated in Iran under various sanctions programs. And so if they're involved in the transaction that is exempt or generally authorized, that might not necessarily allow for the exemption or general license to apply. And then I just wanted to note this Swiss humanitarian trade arrangement, because it was in the news recently. And what the Swiss humanitarian trade arrangement is it was a mechanism set up between the United States and Switzerland, whereby Swiss financial institutions and importers could gain additional comfort from OFAC in the form of written guidance that their activity was authorized if they undertook certain enhanced due diligence activities and engaged in some enhanced reporting requirements to Treasury regarding the activities they were undertaking with respect to Iran specifically. It's for Swiss exporters and Swiss financial institutions, but Treasury has invited other people to submit proposals for similar, other people meaning other financial institutions and countries, to set up similar type arrangements. Here's what I would note. It's not authorizing anything or allowing anything that wouldn't already be authorized or exempted. All it's doing is providing a comfort letter that what you are doing falls under the exemptions and general authorizations, and no action will be taken to you as long as you meet certain conditions. So it's not necessarily a humanitarian channel. It's more, I view it more as enhanced guidance, essentially, if you're willing to undertake some additional due diligence and reporting requirements. There's a couple of FAQs I wanted to touch upon too, only with respect to Iran, Venezuela, and Cuba, but I think they're relevant and can be thought of with respect to other sanctions programs as well. So the first one is FAQ 637 that deals with Iran. That FAQ deals specifically with guidance for non-US persons engaging in transactions related to the provision of humanitarian and consumer goods in Iran. The basic point here is that, again, the US maintains these broad authorizations and exceptions under US sanctions that allow for the sale of agricultural commodities, food, medicine, and medical devices to Iran from the US or by US persons or US owned or controlled foreign entities. And that broadly speaking, transactions for the sale of those types of items are not sanctionable. Remember, we're not dealing with prohibitions, we're dealing with sanctionable. Do they expose you to the designation? Unless they involve persons on the OFAC SDN list that have been designated in connection with international terrorism, proliferation of weapons of mass destruction, and they include those designated Iranian financial institutions. There's a difference between blocked and designated Iranian financial institutions, which you might want to email me about afterwards, because it's broader than the scope of this discussion, but I can get into those weeds, one-on-one with people. Or the Islamic, or any dealings with the Islamic Revolutionary Guard Corps or activity that is subject to other sanctions. So basically, if you're only dealing with a problem because of the Iran embargo, and you're a non-US person, you will not be sanctioned, you'll not be found sanctionable for exporting agricultural commodities, food, medicine, and medical devices, so long as you don't have these other sanctioned parties involved. The next FAQ 665, which relates to Venezuela, provides guidance with respect to supporting humanitarian efforts in Venezuela following the blocking of the government of Venezuela. So Venezuela, the government of Venezuela was blocked last year. And the premise here is that OFAC is committed to ensuring that humanitarian assistance and non-commercial personal remittances can flow to the people of Venezuela. So to that end, what OFAC did is they issued amended general licenses and also issued some new general licenses to ensure that U.S. persons could continue to engage in and facilitate non-commercial personal remittances and export humanitarian items. And when I'm talking about humanitarian items, again, this is thought of as agricultural commodities, medicine, medical devices, replacement parts and components for medical devices, software updates for medical devices, et cetera, to Venezuela. It's important to note that the EEO does not prohibit transactions involving the government of Venezuela that relate to the provision of articles such as food, clothing, and medicine intended to be used to relieve human suffering. So again, IEPA-based exemption included there. Also, a couple other notes on Venezuela. There is a amended general license which authorizes the official activities of certain international organizations such as the UN, that includes its programs and funds and specialized agencies and related organizations, as well as the International Committee of the Red Cross, among others, to engage in transactions involving the government of Venezuela to the extent that the transactions are subject to US jurisdiction. OFAC made one other note in this FAQ, which I point out, and which speaks to an earlier question, which is that if you're dealing in exports or re-exports in Venezuela, even if it's for activity related or activity authorized by OFAC, you still need to consult the Department of Commerce's Bureau of Industry and Security to ensure eligibility of the exportation under Commerce's authorities. So the inquiry doesn't just stop with OFAC. And then finally, I think another one that's important to touch upon is FAQ 708, that deals with Cuba. And that frequently asked question notes that the Cuban Assets Control Regulations authorizes transactions, including travel-related transactions, that relate to humanitarian projects in or related to Cuba. And it sets out a list of the different types of humanitarian projects, but they include, for instance, medical and health-related projects, construction projects that are intended to benefit independent civil society groups, disaster preparedness relief and response, historical preservation, environmental projects, projects that involve formal or non-formal educational training with respect to certain topics, and those topics are entrepreneurship and business, civil education, advocacy and organizing, adult literacy, community-based grassroots projects, and projects related to agricultural and rural development, and also other projects to meet basic human needs. So that's the reason I point that one out, even though it's so Cuba specific, is I think it's interesting to give you an idea of what kinds of activities that this policy of supporting humanitarian efforts might lend itself to with respect to specific licensing. So if you're operating in one of these categories, obviously for Cuba it's allowed, but maybe with respect to a sanctions program that doesn't allow it, you can point to the Cuba regs and say, hey, I know this is allowed in Cuba. Obviously there's different policy considerations here, but it seems like this is something the US has been open to in other sanctions contexts. So we believe authorization should be granted for this type of activity in our particular context, if that makes sense. It's just another thing you can point to use to more vigorously advocate in your licensing applications for your authorization. Okay, I don't know if there's any questions before we go to our last section here, but I'm happy to answer those.
We have a number of questions that have come in, but in the interest of time, I think what we'll preserve the questions, and we can share the answers by email on the page that will be on our website with the recording of the webinar, as well as the PowerPoint, and notify people by email when that's posted. So I encourage people to keep submitting the questions, but now let's go to the next topic, which is also pretty crucial here, with practical compliance challenges.
Sure, yeah, and I will move quickly. So I apologize. You know, when I was mapping out this presentation, it seemed like it was going to go so fast, but yeah, I guess it just kind of underscores my passion for sanctions that I've been able to talk so much about these different areas. But let's talk about compliance challenges, and in doing so, let's take a look at OFAC's compliance framework. There are 5 essential elements of a sanctions compliance program, and I think it's important to note that OFAC put out a document last May which set out kind of their expectations for sanctions compliance, and it sets forth this compliance framework and identifies these essential elements. So this isn't just Erich Ferrari's own take on it. This is actually coming from OFAC. And what they view as the 5 essential elements are management's commitment to compliance, conducting risk assessments, adopting internal controls, testing and auditing compliance efforts, and also training on those compliance, on that compliance program and process. So with respect to management commitment, this means that management should be involved in reviewing and approving a sanctions compliance program. They should provide sufficient authority and autonomy to the compliance function. And they should also provide adequate resources, human capital, expertise, and technology to that compliance function. And they should also promote a culture of compliance and recognize the seriousness of compliance via implementation of remedial measures, which we'll talk a little bit about in a moment. With respect to risks assessments, those assessments should be tailored to identify the manner and frequency or transactions to account for risks, and there should be a methodology that's developed to assess the risk. So institution of internal controls is another one of these essential elements as well, and it kind of bleeds out of this risk assessment process, but instituting internal controls speaks to the adoption of policies and procedures that institute controls such as screening, escalation within the organization, review of red flagged transactions, and reporting of violative transactions to account for the risk assessment and risk profile of the particular entity. In other words, there needs to be a mechanism to enforce these policies and procedures, and there should be record-keeping practices aligned with those policies. And these controls that we're talking about should also call for the immediate remediation of any identified weaknesses in the sanctions compliance program or in any sanctions compliance practices. Finally, policies and procedures, well, actually not finally, but policies and procedures should be communicated to all staff, and there should be personnel dedicated to implementing compliance policies and procedures throughout the operations. Now, moving on to the testing and auditing element, what we're talking about here is the maintenance of a compliance function that is accountable to management, that is independent of those components of a business or an organization that it is auditing, and that is sufficiently staffed and resourced. So this element should account both for the risk assessment and the profile, and it should likewise be able to identify remedial measures upon discovering a compliance failure or weakness. And then finally, training element is pretty self-explanatory, but it speaks to communicating sanctions compliance related information to necessary parties in an organization. That training should be appropriate both in its scope and in its frequency, and account for the risk profile of the particular entity. It should also account for the necessity to identify how to remediate compliance failures or weaknesses in the compliance sanctions programming. Also, another tip here is to make sure that the training program and all materials related to the sanctions compliance training are readily available to all staff, even if those might not be the most relevant staff members to have access to those materials. The framework also does a good job of setting out some common sources of compliance failings. We won't go into all of them, again, due to time and just because it's beyond the scope of this particular discussion. But some of the more common failures occur where there are no sanctions compliance programs at all. And that leads to sanctions violations. And that also leads to aggravated enforcement responses by OFAC. Second, OFAC identifies in the framework that many people misunderstand the jurisdiction or scope of sanctions prohibitions. So, and that leads to violations. So as you noted, or you probably noted, I've discussed U.S. persons and jurisdictional and all these different types and jurisdictional requirements and all these different types of categories and types of sanctions throughout this presentation, and I've been going on ad nauseum about them. The reason why is because there is so much confusion and misunderstanding, and with respect to jurisdiction and the scope of prohibitions, and that often leads to violations, as OFAC itself has pointed out. And then third, it notes a lot of compliance failures when in the processing of non-U.S. transactions through the U.S. financial system, and that typically occurs through processing U.S. dollar clearing, because that typically goes through New York. So again, I spent some time pointing out that example about the Turkish donor sending money in euro to the Emirati charity and it going through a foreign branch of a U.S. financial institution, that causing a sanctions violation. That's exactly the reason why I brought it up, because it is such a common source of compliance failures and violations. So key points here are identifying U.S. nexus. I think we've talked enough about that. I won't spend any more time on it. Another key point here is, how do you conduct due diligence on counterparties? And we could have a 90-minute course on that alone. Let me just give you some key takeaways. One, who are you dealing with, right? So do you really know the organization that you're dealing with? Do you know who owns that organization, how they're structured, who their officers are, who their directors are, what areas they operate in geographically, or from a humanitarian perspective, what types of programs are they administering? Who do they work with, right? Who are their vendors? Who are their suppliers? Who are maybe kind of downstream recipients of donations from them or services that they provide? You need to know all of that. And there was an old saying that you don't need to know your customer's customer. That's not true in the sanctions context. You really do need to know not only your customer's customers, but also their customers, their vendors, and the counterparties they're engaged with. So conducting due diligence, starts there with knowing who you're working with. It also requires thinking a little bit about the transactions. Like, does the activity you're undertaking make sense for the geographic region you're dealing with, the type of organization you're dealing with? Does everything add up, and is it clear and transparent? And then also, I would note here, part of conducting due diligence is also an assessment as to the law and what the law requires. So, is there are we acting completely outside the scope of any prohibitions? If not, is there an exemption that applies? If not, is there a general authorization? If not, do we need a license? If so, is there a statement of licensing policy? So considering the legal ramifications and what exemptions, authorizations are available is another way to conduct due diligence, at least with respect to the transactions. So as part of that last piece, you might need to obtain guidance from OFAC. And so how do you do so? There's a number of ways to do so. In my opinion, the best way to do so is to actually seek written guidance from OFAC via a request for interpretive guidance. We just talked about how long that goes to the licensing division, and we just talked about how long licensing takes. So why would you want to go to licensing to get guidance? Here's the problem. If you call OFAC and someone talks to you, that's not the formal agency position, right? So you can rely on it, but it's not as safe to rely on, and I'll talk about that in a minute, as would be a written guidance letter from the licensing division. So you can go to OFAC and you say, look, we understand that there's a general license or exemption that applies here, but we're not sure that the scope of that exemption or authorization covers everything we want to do. So please give us guidance whether this covers, XYZ activities. I find, so you can do that as an organization, an individual, company, but I find that actually it's easier to get guidance from OFAC if a group comes in, either through a trade association or an industry group, and says, look, this is a common problem that our industry or our people operating in our field are experiencing as a result of the regulations, and we need guidance. So you'll see a lot of FAQs from OFAC come out through that process where OFAC is just getting the same questions over and over again. And so they say, all right, let's just put out some public guidance to address this issue. So if you can kind of consolidate your efforts with others in your industry or within your field and put forward, several questions to OFAC to obtain guidance, that's usually going to get a quicker and more robust response than just individual requests for interpretive guidance going into in the licensing division. I would note, and maybe some folks who are still on the webinar already know this, but there is a hotline and an email address where you can get advice from OFAC. I would caution relying on that, and this is not to disparage anybody who's manning that hotline or email addresses, but I have seen guidance that was provided through those means that was later said to be incorrect by OFAC itself. So OFAC has actually noted that certain advice provided by email address was not entirely accurate. And so I would be very cautious about relying solely on the hotline and the email address to get your guidance. A lot of people like to do so because it's much quicker than putting in a license application or interpretive guidance request, or seeking guidance through an industry group or a trade association. But you can't necessarily always rely on that advice 100%. So not to be disparaging to OFAC or the people manning that email address or hotline. Sometimes they don't have all the facts, or maybe they're not understanding the inquiry, but you should take caution in relying on advice from those sources. Overcompliance by banks is my last point. I think we've already kind of touched on this. This is the biggest hurdle in sanctions compliance, because you can figure everything out and say, okay, we know this is authorized, we're comfortable with who we're dealing with, everything adds up and makes sense, and you go to your bank and say, send $50,000 to the Emirati charity, and they say, no, we're not going to do it. Why? Sanctions concerns. Well, we already looked into this and everything's fine. Well, it's our risk policy that we're not going to do it. So take it elsewhere. In extreme circumstances, I've seen not only that response from a bank, but also, yeah, we're not going to do it, and we are going to close out your bank account and you can't bank here anymore. That happens. It's happened multiple times. This is the biggest hurdle to overcome, again, for all the reasons we discussed earlier. Banks are over-complying for a variety of reasons. So how do you mitigate this? I think the biggest key here is just knowing what you're getting into before you commit to anything, which is knowing your bank, talking with your bank, explaining what you do, explaining what you might want to do, and just seeing their reaction. Saying, hey, we want to be able to send donations to Iran for XYZ project. If we get a specific license to do it, are you going to allow us to remit the payments? And see what they say. Be transparent with them. If all else fails and you're being transparent with everyone and you've addressed everything and you just can't find a bank to do it, as a last resort, I have seen OFAC step in and talk to banks and see if they can assuage the bank's concerns. And sometimes that works, sometimes it doesn't. But OFAC, believe it or not, has been pretty helpful in talking to financial institutions that are over complying and that maybe are misinterpreting the regs or taking a position that's unreasonable. So that would be my last kind of pro tip for you on that. It's the biggest problem. There is no silver bullet to it, but hopefully you can follow some of those steps and overcome that hurdle. So that's all I have, Kay. Are there any questions, or do we want to wrap up today?
Wait, We have a few minutes before the hour. Let's look and see, look at the questions. And some of these are so particular that we may have to do them by email after the event. But here's one. Could you describe OFAC comfort letters? What is that, and how does that work?
Yeah, when you hear the term comfort letter, what it really is that request for interpretive guidance, which is, hey, your activity does fall under an exemption or a general license, and therefore you don't need authorization. So important note on comfort letters, because that's kind of a term that a lot of people use. I refer to it as guidance letters, but they're usually heavily caveated, and there's usually some language in there about, to the extent that your activities fall under this general license, then you do not require specific license. So that gives OFAC a little bit of wiggle room if something does go wrong to say, well, we said to the extent the license applies, and here it didn't apply, for whatever XYZ activity might be. But that's what a comfort letter is.
Here we have an interesting strategy question. Here, if you're trying to determine whether your activities fall under a general license, is there an oversight or somewhere in OFAC to contact to make that determination? Or would it be better to have an application for a specific license they would reject because it's covered under the general license? Trying to figure that out.
So whoever's asking this question is very savvy, because that's a great point. And sometimes people put in specific license applications just to get a return without action letter more quickly than you would a request for interpretive guidance. So you kind of play dumb and you say, hey, OFAC, can you give me an authorization for this? And OFAC will respond more quickly because it's a license application as opposed to a request for guidance. And they say, oh, you don't need one because, there's a general license. To the extent this general license applies, we can't issue one. So that's a very, very good question, a very savvy one.
And just one more, are laptops with U.S. components allowed to be used in countries such as Syria and North Korea under the humanitarian license?
So I don't have an answer for that off the top of my head. I'd have to go back and look at those regulations and that guidance. So whoever asked that question, feel free to email me and I'll take a look. In Iran, they can, depending on the type of laptop, because there's a general authorization. But I have to look at Syria and North Korea specifically.
Okay, and then the last question is about how to get the copy of the PowerPoint. We will be posting it on our website along with a link to a recording of this webinar. And we'll at the point we post that on the site, we will email all the participants here so that you have that information. So I want to thank you, Erich, for such a rich and robust presentation of a topic that has perplexed me and I'm sure many others for a long time, and provided a lot of very helpful context and clarity and some good ideas about things I want to read up on further, or ideas we might pursue in our work. So thank you. Thank you very much.
Thank you.
And thank you for everyone for participating. And we will, as I said, be sharing this information, and also want to alert you that we will be, our next webinar will be on June 10th, addressing the IRS rules for fiscal sponsorship relationships. You should be getting notice about that. So thank you, everyone. And again, thank you, Erich, especially.
No, thank you. Thanks to everyone. Thanks. Bye. Hey, Kate, can I get a list of these? Is there any way to get a list of these chats? I just kind of wanted to get the feedback and the other